Hello, and welcome to this Gowling WLG webinar on TUPE and pensions, the tricky issues. We're going to focus on redundancy and Beckman issues today that arise out of a TUPE transfer. So I'm Siobhan Bishop from the Employment, Labour and Equalities team, and I'm joined today by Jane Fielding, a partner in our team, and also Liz Wood, a director in the combined Human Resources team, both of whom have got an extensive amount of experience advising on the issues we're looking at today. The presentation will last for approximately 35 minutes with some time for questions at the end. And before we get started, we'll just go through a few housekeeping points. The webinar player itself has a few simple controls. The most important are the volume adjuster and the full screen option, which are in the bottom of the right-hand corner of the player. There are also some tabs along the top which you can click on to access details about today's speakers, the slides, and also some downloads with more information. If you have a question at any time, you can ask this. Simply click onto the Ask a Question tab, type in your question, and then click Submit. We'll try and answer as many questions as we can in the time we've got available today. There is also a poll tab. Don't need to worry too much about that yet. There are a couple of points in the webinar where polls will automatically flash up on your screen, and would really encourage you to take part in those at that time. And finally, if for any reason you can't see the current slide, just click on the slide tab to get back to it. So today we're going to look at the two issues. Firstly, collective redundancy on a TUPE transfer, and then dealing in more detail with Beckman issues. So first of all, I'm going to hand over to Jane Fielding.
Thanks, Siobhan. So I'm going to talk about the two overlapping regimes where you've got a TUPE transfer and also collective redundancies that the incoming employer wants to make. So that's where you're hitting the threshold for collective redundancy consultation. And often those two processes go hand in hand because perhaps a new contractor to deliver the service model that they've won the bid on the basis of needs to make some redundancies to make the contract work for them. So there are similar regimes in terms of information and consultation, both for TUPE and collective redundancy consultation, as you can see from the screen. There's an information obligation consultation, and then you've got to do that process with representatives of the staff rather than directly with the staff themselves. So taking TUPE first, on every TUPE transfer there is an obligation to inform the representatives, and that's separate from the obligation to consult, which we'll come on to. And you have to give that information long enough before the TUPE transfer to enable the employer to consult the representatives of any affected employees. And note that's affected employees, not just the employees in scope. So it could be, if you're the transferor, people who are left behind but who are nonetheless affected by the change in the business. And it's an obligation to inform appropriate representatives. So the idea is it's a collective scenario. People are better represented if they've got spokespeople on their behalf. And also from an employer's perspective, it makes it a slightly more streamlined process, so you can have group meetings rather than have to meet with everybody individually. So who are the reps? Well, if there's a trade union recognised by the employer for all the staff or a section of the workforce, then for those staff to whom the recognition applies, the trade union has to be consulted. For other staff, or where there's no recognition at all, the employer can choose between consulting with reps who've already been elected for another purpose, as long as their remit is wide enough to cover the TUPE transfer, or the employer can invite the employees to specifically elect representatives for this TUPE transfer. And there's a qualified exemption there. If you are in a business that employs fewer than 10 people, you can just consult directly with the individual employees. You don't have to do the election mechanism. So what about the duty to consult? Well, it's compulsory to consult if an employer envisages taking measures in relation to any affected employees. And that obligation is to consult with the reps with a view to reaching agreement. Now that's the compulsory consultation obligation, but what case law tells us is even if no measures are envisaged, an employer should leave enough time in the timetable for voluntary consultation to allow the staff to ask any questions, raise any concerns they might have. So that begs the question really, what does measures mean? The transferee has a duty to tell the transferor of any measures it envisages taking in respect to the staff it inherits. And measures, according to case law, because it's not defined in TUPE, is a pretty low threshold. So it's any change as a result of the transfer that impacts on the staff. So, for example, a change in payroll date with a consequent change in tax code and deductions is a measure and should be consulted about. And clearly things like redundancies are major changes for people and therefore definitely trigger the duty to consult. Similarly, pension changes, I'm not going to stray into Liz's territory, but often on a TUPE transfer, pension changes happen. They are measures and should be consulted on. And just finally on consultation, it's defined as with a view to reaching agreement. So it's not negotiation. The employer doing the consultation ultimately has the final say in what happens, but it is a sort of enhanced consultation obligation because it's supposed to be done with a view to reaching agreement with the reps on points that they raise. So there are a number of tricky issues on TUPE consultation which can trip people up. So before you start, when you're planning, if you've got a union, check it's properly recognised. Does it represent everybody affected? If you are going to consult with a pre-existing body, then check that they have the right authority and all the people on that body have got terms of office that haven't expired, for example, which could trip you up. And why is it important? Well, a football-themed photo there, given where we are in the football timetable, there is a hefty penalty. So a good shorthand for what's on the screen there, if you're trying to get the attention of your commercial colleagues or the finance director, is if you mess this up, it's a quarter of the annual wage bill for all the affected staff. And it is a penalty, it's not compensation. And what tribunals will do is, if an employer has done nothing to try and inform and consult, then they will give that maximum 13 weeks pay. If you've done something, then you get the opportunity to try to get the tribunal to reduce that award to something more commensurate with the level of default. There is a special circumstances defence, but it, like all exceptions, is construed very narrowly, so I wouldn't get too excited about relying on that. Generally, arguments around confidentiality, getting into financial difficulties quickly, preventing people from doing information and consultation more thoroughly, don't tend to carry much weight with tribunals. So the message is basically do as much as you can, even if that's not going to be fully compliant. In terms of liability, if we're talking about the transferor consulting with its employers and that isn't done properly, then that is a liability that can transfer to the transferee, like most TUPE employment rights. And so liability there is joint and several. If it's the transferee's failure to consult with its own staff, that's clearly not anything to do with the transferor, and that purely sits with the transferee. And as many of you will know, all of you probably, you can't contract out of TUPE, you can't contract out of these duties applying, but what you can do is use your contract, whether it's an M&A scenario with the other side or in an outsourcing scenario with the customer if you're the contractor, to try and reapportion the liabilities so they sit where they should in terms of the commercial deal. So if the transferee is driving the timetable because they want to get on with the deal, they want to shortcut the process, then it's right and appropriate for the transferor to be asking to be indemnified for that. So moving on from TUPE to collective redundancy. Again, this is a collective duty, again, to make sure staff are better looked after. And again, it's informing and consulting. And this obligation is triggered when an employer is proposing to dismiss as redundant 20 or more staff at one establishment within 90 days or fewer. And you can see that unlike TUPE, there are some minimum time periods here. They are minimum time periods which have to elapse between the start of the information and consultation process, so when the information is given to the reps, and the first of the redundancy dismissals taking effect. And as you can see, the length of time depends on how many staff are concerned. So 20 to 99 people, it's 30 days, 100 or more, it's 45. Now, there is clearly an overlap with the TUPE process. There are some similarities. The appropriate representatives are the same. There's a similar penalty. There is a special circumstances defence, but again, don't get too excited about that. But there are various differences. which can trip up the unwary. We don't have time to go into all of those today, but if you look at your download tab and go through that, there is a document we've uploaded there which sets out what the differences are, and you can print that off and keep that for future reference. So that will give you the details of what has to be given by way of information and more information about the consultation details. But the one thing I wanted to flag is, for redundancy, unlike TUPE, there is a separate obligation to deliver to BIS, so to the Secretary of State, with a copy to the representatives, an HR1 form. And that basically gives notification of the proposed redundancies, the numbers, timescale, etc. And it's to help the local job centre essentially plan for people coming and needing their support. It's a criminal sanction not to deliver that form. And so, again, it's definitely something that you should factor into your planning. It has to be given in good time before the first redundancy takes place, but usually people will give it at the same time as they start the information process with the reps. Again, why do you need to do that? Well, there's a pretty hefty penalty, similar to TUPE, but 90 days gross pay, and the same principles will apply to how a tribunal will approach awarding that penalty. And if you are in a TUPE and collective redundancy scenario and you do neither, you follow neither process, then the tribunal can award both of those awards. So that's an even heftier penalty that you're facing. So one of the practical difficulties that comes up when there's a TUPE and redundancy scenario is that often the transferee doesn't want to have to wait to inherit the staff under TUPE before it makes the necessary redundancies. Firstly, it wants to get on with things. Secondly, it doesn't really know the staff. And so often there's pressure for the redundancy dismissals to be made before the transfer. Now, that causes a bit of an issue under TUPE because only an employer can be sure of carrying out effective redundancy consultation with their own staff, and obviously up to the point of the transferee is not the employer of the people it's going to inherit. So this has caused sort of practical issues, and often this is dealt with by the transferor agreeing to let the transferee in to do the consultation, as long as they're indemnified, and the transferee takes the risk, the risk that the employees don't challenge the fact the consultation has effectively been done too early. So the government was aware that this issue is causing difficulty in practice, and when TUPE was last revised in 2014, they tried to do something to alleviate the difficulties for employers. So they introduced an opportunity for a transferee to elect to do the collective redundancy consultation before the transfer, as long as they got the transferor's agreement to do that. And the mechanism is a legal fiction whereby the people remain employed by the transferor, but there's a legal fiction that treats them purely for collective redundancy consultation purposes as if they are already the transferee's employees. Now, it's a kind of one-off choice. The transferee can only cancel this once. So once they've started, they can cancel it, but they can't then start it again. They would then have to restart after the transfer. And obviously they have to give notice to the transferor and to BIS and to the reps that they are no longer going ahead with this, and they're going to wait and do it after the transfer. So it's helpful to some extent, but it's not necessarily an ideal solution.
Okay, thanks, Jane. We're now going on to our poll question, which is an opportunity for you to get involved about what you do in practice, and that should be flashing up on your screen now. So it's over to the audience to ask you, what do you do in practice? When faced with 20 or more redundancies on a TUPE transfer, does your organisation collectively consult and dismiss the employees beforehand, before the transfer? Collectively consult and dismiss the employees after the transfer? The third option is to use this pre-transfer collective consultation process but still dismiss the employees after the transfer, or some other mechanism and process that you use. So if you want to click on which option you use in your organisation, some responses are coming in already, and I'll just give you a few more moments to to decide which is the most appropriate answer for you, because it's a really interesting issue as to what is happening on the ground, which isn't always necessarily in line with what the legal position is. So a few more answers, and I'm going to display the results now. Okay, so we've got the vast majority there, nearly half of you, showing that you collectively consult and dismiss the employees before the transfer. That's by way above the other options. So Jane, that's really interesting.
Yeah, people still take the more cautious approach of doing everything afterwards. And the use of this pre-transfer mechanism still leaves some tricky issues. So if we go back to the main slides, then I can carry on and highlight what some of those are. So one of them is it definitely needs the transferor's agreement to do it, but there's nothing in TUPE that then says the transferor has to cooperate. So there has to be some discussions with the transferee to get the transferor's buy-in to allow access to the premises to see the staff. So just getting the transferor's agreement isn't the end of the story. There can also be issues where the redundancy consultation straddles the transfer date, so it starts before but finishes afterwards. Have you got the right representatives? Are they actually going to be there before and after, or are they not actually coming over on the TUPE transfer? So all of that needs to be factored into the planning. Also, as I said earlier, only applies to the collective aspects of redundancy consultation. So it doesn't permit individual consultation with those selected for redundancy to be consulted with on that basis beforehand with any confidence for the transferee that that will be a fair dismissal. So again, it's more prudent to do that after the transfer has happened. And there are also issues around pooling. Should you pool with your own staff if you're the transferee, or is it okay to ring fence to just the people that you're inheriting? And also there's the issue of when do you give notice and who can give notice. Only an employer can give its employees notice to dismiss. So to be completely safe, it's better for the transferee to issue notices of dismissal having inherited the staff, even if that is then achieved by way of notice and an immediate pile-on, so they don't carry on in the employment. And there are risks around dismissing pre-transfer, which we're going to come on to in a moment. But before we do that, I just wanted to finish on pre-transfer consultation. As I think the poll showed, we see it used occasionally, more often in an M&A scenario, where you've got two parties contracting directly, and it may suit both of them commercially for this to be done. It's less common in our experience in outsourcings, particularly second-generation outsourcings, where the outgoing contractor who's just lost a contract to a new contractor isn't really going to have much commercial interest in cooperating with that competitor. So there, unless the customer has thought ahead and built into the contract with the outgoing contractor an obligation to cooperate with the transferee if asked to do this type of consultation, then it rarely happens. So the transferee has to carry out a risk and benefit analysis, basically. It's going to be faced with requests for indemnities from the transferor, potentially, if those aren't already catered for in the existing contracts. It's going to have to come to some sort of agreement about the level of and detail of cooperation by the transferor, and that's going to take time and effort to get agreed, another document to be sorted out in the transaction. And it may be that some of the staff need to be dealt with by way of opt-outs and settlement agreements again, which may involve the transferor and their cooperation. So back to the future, I say, in the sense that most situations are still dealt with without this pre-transfer consultation being used. I said we'd come back to looking at dismissals and the risk of making dismissals for redundancy or otherwise before the transfer. The problem here is that we've got automatic unfair dismissal territory with TUPE. So if the sole or principal reason for the dismissal is the transfer, then it's an automatic unfair dismissal, unless the employer can show that the sole or principal reason was actually an economic, technical or organisational reason entailing changes in the workforce. Now, until recently, case law said that changes in the workforce to be an ETO had to relate to the numbers or the functions. And often in a TUPE situation, perhaps the new contractor is going to deliver the service from elsewhere, perhaps the current one's in Bristol and the new one's in Glasgow. That will involve a geographical relocation, which does not fall within that definition of an ETO. So again, in 2014, when making the changes, the government recognised this problem and extended the definition of ETO to cover dismissals arising purely out of a relocation. So that's helpful to some extent, but there are still some risks with taking that approach. So the two main risks of dismissing pre-transfer are that under European case law, the transferor cannot borrow the transferee's ETO reason to achieve a fair dismissal. So in that example I just gave of the move from Bristol to Glasgow, the transferor needs all the staff in Bristol until the last day of the contract. It's then the transferee that has the need for those people in a different location in Glasgow, and it's the transferee's ETO reason. So if the transferor dismisses pre-transfer down to that relocation, then that creates an automatic unfair dismissal, which the transferee will then inherit. The second issue is that a change of location can still trigger an ordinary unfair dismissal claim, in the sense that there is an opportunity for staff, if there is a substantial change in working conditions to their material detriment, or something that constitutes a repudiatory breach of contract in connection with a TUPE transfer, they can resign and claim unfair dismissal. And we have seen cases recently where that has happened, where a relocation has impacted, for example, on someone's ability to drop their children off before they go to work. It's sort of doubled their travel time, or they can't actually get to work on time. So it doesn't happen that often, but it is a reality. And if somebody resigns and objects to transferring, that claim will stay with the transferor, even though the change of location is not their choice or within their control. So you can see the need for indemnities and discussion around that there. So there are still risks, despite the 2014 changes, to making redundancy dismissals pre-transfer. I've outlined those on the slide there in summary. I've mentioned them all already, so I'm not going to go through them again. But what this shows you is that in each TUPE and redundancy scenario, you're going to have two broad things to be thinking about. The commercial pressures. So are you a transferee coming in needing to make redundancies? How quickly do you need to do that to deliver on your contract? How cooperative is the other side? If you're in an M&A situation, you might have a more cooperative other side, not necessarily. But in a second generation outsourcing, those commercial pressures are going to be very different, and you've got the customer dimension to build in there as well. But there's also balancing that with the employee relations side of things. So if you're in a collective redundancy scenario, you're going to have a group of people who are going to be going, a group of people who are going to be transferring. And the people transferring will look at how you, as their new employer, deal with the colleagues that are not coming across, and how you deal with making them redundant. And as your first sort of contact with those staff that you're inheriting, it's an important thing to plan for and to get right, and to decide which shortcuts you're prepared to take, given the balance between commercial pressures and employee relations needs.
Great. Thank you very much indeed, Jane. And just a reminder about that download that Jane mentioned, which is under the download tab. And there's also another one there as well about Beckman rights, which is the next topic. So I'm going to bring in Liz Wood now, who will be covering identifying and managing Beckman rights.
Thanks, Siobhan. So I'm going to be looking at the vexed question of Beckman rights. So these are the potentially expensive pension rights that can form part of a TUPE transfer, even though they relate to the occupational pension schemes of the transferor. So from the perspective of the buyer or the new provider, there are clear incentives to identify these kind of rights sooner rather than later, and factor them into any TUPE process you're considering. And so what are the incentives? Well, mainly an assessment of what they might mean in financial terms, but also the controls that you might have as a new employer in relation to the transferring employees and in relation to those rights, and also in terms of any deals that you might be able to reach with the transferor employer in the context of a sale or an outsourcing. So I'll begin by looking at what Beckman rights are and how they arise, and then I will consider how far the duty to provide such rights extends to a transferee employer, and then I'll give you some pointers around how to deal with them if you've identified they exist in the context of a TUPE transfer. So we have the automatic transfer principle set out in TUPE, whereby all terms and conditions of a transferring employee's employment will transfer across to the new transferee employer. But there's an important exception to this principle, which is found at Regulation 10 of TUPE. And this essentially says that all the usual transfer principles do not apply to so much of an employment contract or collective agreement which gives rights, powers, duties or liabilities in connection with an occupational pension scheme. So in shorthand, it means that there is a broad exclusion for occupational pension schemes, and rights, liabilities, duties and so on associated with those remain with the transferor employer. Now, just to be clear, this applies to occupational pension schemes only, and that's essentially any pension scheme established by the employer to provide retirement benefits for its employees. So importantly, personal pension schemes don't form part of this pensions exclusion. Rights associated with personal pensions are subject to the general TUPE transfer principle. And none of what I'm going to come on to talk about is relevant to personal pension schemes. Now, in the context of Beckman, we're talking only about defined benefit or final salary occupational pension schemes. And in broad terms, this Regulation 10 exclusion means that an employee who's a member of this type of scheme won't have the right to continue participation in such a scheme once a TUPE transfer has taken place. And so these defined benefit final salary schemes where essentially an employee has a certain amount of quantifiable pension when they come to retire that the employer has promised to provide. So under this exclusion, the bulk of pension rights remain the responsibility of the transferor. But this next slide just is a reminder of the fact that an occupational pension scheme has a number of rights that are available under the scheme rules. And these are primarily rights that you would get in terms of having reached your normal retirement age at the end of your working life with an employer, but also rights that you might get in circumstances of ill health, and also pensions that might be payable to a survivor, so for example a spouse or civil partner, in the event of the death of a member. But there will be other rights that that pension scheme might provide, and these are the types of rights that might be subject to a TUPE transfer because of the wording of the pensions exclusion found in TUPE, which talks about old age, invalidity and survivors' benefits. So what kind of rights might these be? Well, we firstly had a case decision on this in 2002, and this was an ECJ decision in the case of Beckman. Now, Ms. Beckman was a quantity surveyor and she was a member of the NHS pension scheme, and she was subject to a TUPE transfer to a private company. Now, under that NHS pension scheme, before the transfer, she'd been entitled to very generous early retirement benefits payable on redundancy. She was then subsequently made redundant after the TUPE transfer, and her new employer didn't accept responsibility for those redundancy terms which were payable from the old NHS scheme. And this ultimately went up to the ECJ. And the ECJ said these benefits that are payable in circumstances of an employee's redundancy are simply not old age benefits. And so therefore, looking at the wording of the TUPE exclusion around pensions, they don't fall within that exclusion referring to old age, invalidity and survivors' rights. And so therefore, these rights arising on redundancy, giving you enhanced terms under the pension scheme, would be capable of transferring. So that was quite a seminal decision that we had there on Beckman, and that's why we therefore talk about Beckman rights. The next decision we had on this was that of Martin, and that was just a couple of years later, but it was decided around the same time as Beckman, and it followed the Beckman rationale. And in this case, we had nursing lecturers who had also been members of the NHS pension scheme. They were also subject to a TUPE transfer, and in this case, they were subsequently dismissed in circumstances which wasn't described as redundancy, but the Employment Tribunal said was in the interest of efficiency of the service. And again, they said, well, actually, under the NHS scheme, we would have got enhanced rights as early retirees and therefore we want to take the benefit of those rights and they should transfer. And the ECJ agreed. It said these again are not old age benefits, these are early retirement enhanced rights, and these are liable to transfer under the general TUPE provisions. So these decisions had significant implications for corporate transactions, because essentially what this had flagged was that there might be rights that would transfer in connection with an occupational pension scheme, but transferees were very much left in the dark around how they would assess the financial liability for providing those kind of benefits. But what we didn't know after Beckman and Martin was a number of things. Firstly, whether these decisions only applied in a public sector context. So those Beckman and Martin decisions had been in relation to the NHS pension scheme. There certainly have been arguments that this might not be the case if you had a private sector to private sector TUPE transfer. There were questions about whether, if there were consent questions attached to those early retirement rights, whether those would transfer, and also how much the transferee would be liable to provide this enhanced pension. We then had the decision of Procter & Gamble in 2012, which is why you've got an image of toilet tissue up on your screen, because this was around the sale of Procter & Gamble's European toilet tissue business. And the parties here recognised that there were Beckman liabilities associated with the transferring employee's employment, but the parties simply couldn't agree the value of those Beckman liabilities. Procter & Gamble said that the buyer of the business simply didn't have any exposure, and so therefore the rights attached to those Beckman rights were £0, and the buyer said that these rights were prohibitively expensive and worth around £19 million. So this is essentially why it reached the High Court. Now, the Procter & Gamble decision was extremely helpful because it clarified a number of things that we didn't know. Firstly, the decision said that this was not restricted to a public sector context, so this does apply to private sector TUPE transfers, and the judge was willing to give Beckman and Martin rights a very wide possible interpretation. The case also confirms that if the early retirement right is discretionary, so it's subject to employer consent, that consent would transfer to the new employer. So employees would have an expectation of being treated fairly by the transferee when considering such a right. And the judge said that the duty to consider the request should be made in good faith. But interestingly, the judge also said that the employer was entitled to consider its own financial interests. And that's relying on a case called Prudential. And I think that's particularly helpful for transferee employers, because they essentially might want to have a check and see if there are consent provisions attached to these Beckman rights, to see if they then want to exercise the discretion to decline to allow those rights to be exercised. What Procter & Gamble also said was that these rights only extend to the enhancement. So what this means is that the deferred pension that's payable from the transferor's occupational pension scheme remains the responsibility of the transferor. The transferor is essentially funding that benefit through that occupational pension scheme that has remained in place with the transferor. So that is not changed by Beckman or Procter & Gamble. But what the judge here was saying was that if there is an enhanced early retirement or redundancy pension that's payable, the transferee will be liable for the cost of that enhancement. So you're essentially deducting off the cost of the deferred pension as against the enhancement cost. So again, that's helpful for transferee employers because it avoids significant additional costs that would be provided in terms of having to provide a deferred pension in addition to the enhancement. The judge in Procter & Gamble also said that this enhancement only lasts up to the date of the member's normal retirement age. So essentially at the point at which the member reaches their normal retirement age, be that 60 or 65 under the scheme rules, for example, that then becomes an old age benefit. So it's essentially morphing in nature, and it then falls under the pension exemption again. So it's an old age benefit that then remains with the transferor. So again, that restricts the transferee's potential liability here. So moving now on to practicalities. Well, how do you manage these Beckman rights, knowing what they are? So I've summarised on this slide just a handy aide-memoire in terms of what this Beckman right is. And in terms of what you're looking at, well, if you're dealing with a future TUPE transfer, the key questions that you need to ask yourselves are the transferring employees currently, before the transfer, members of a defined benefit pension scheme, or are these transferee employees formerly members of such a scheme? Because in either scenario, they might have these Beckman liabilities which would transfer across to you as the new employer. And in either of those circumstances, the first point of reference is to check very carefully the relevant scheme rules in order to establish whether there is a Beckman liability. And you may well need legal advice on that because it's not always desperately clear from the scheme rules. It's also worth noting at this point that there are some industries or sectors where defined benefit pension schemes are more common. So, for example, in the public sector, obviously with the examples of the Beckman and Martin cases where we looked at this in the first instance, but also privatised industries, so utilities, transport, nuclear power. Manufacturing businesses often had these kind of occupational pension schemes, financial services and other professional advisors, and more generally the longer established FTSE 100 and FTSE 250 companies. So the key points are doing your due diligence, so checking the pension scheme rules. Are there enhanced rights payable on redundancy or on early retirement at the employer's request, or early retirement on business efficiency grounds? And at this point, it may be wise to get actuarial input, so essentially number crunching on the value of those rights, very much taking into account the Procter & Gamble decision that you as a transferee would be only liable for the enhanced elements of that pension. In terms of practicalities, again, it's important to understand the consent position. So you as a transferee, do you have control over those rights? Do you have the right as an employer to decline to offer that enhanced benefit on a redundancy situation? Crucially, it's important to try and get some sort of indemnity protection from the transferor if you're the transferee. In my experience, these need to be very much tailored to the situation of the buyer and seller, or in an outsourcing, it will depend on the negotiating position of the two parties. And you might also want to have some sort of agreement as to who bears the costs of any such liability arising. I'd also say be cautious if you're considering a price adjustment mechanism as part of the transaction, because clearly in Procter & Gamble that turned into an absolute nightmare in terms of establishing what exactly the purchaser needed to pay for the business, because they essentially ended up with a bun fight around the costs associated with the Beckman liabilities. The final practicality is the really challenging question around how you as a transferee would provide these Beckman rights ultimately to the employees if you're making them redundant. So the scenario in which you've recognised that these Beckman rights exist, they're either not subject to any consent, or you have exercised your discretion and granted the consent rights here. But how do you give those rights to the employees? You're not going to be a participating employer in the transferor's pension scheme. You're unlikely to want to do so because of the funding associated with that. In my experience, there are three main options available to transferees to deal with this. The first is simply a promise to pay a certain amount representing the value of those rights once you've established what the value is. I've also seen it done where a transferee offers to provide a replacement Beckman right through an existing, for example, defined contribution scheme, so essentially a lump sum into that scheme to deal with those liabilities. Or alternatively, transferees might want to try and negotiate with the transferor and probably the trustees of the transferor's pension scheme to essentially pay a top-up to provide that enhancement through the scheme rather than having to deal with it outside the pension scheme of the transferor. There are a number of issues associated with all these options, including tax issues. So it's clear that this remains a complex issue to deal with. But fundamentally, the more due diligence that you can do to identify Beckman liabilities and the better indemnity cover you can get as part of any transaction, remains the best way of dealing with the costs and risks associated with these types of rights.
Great, thank you very much, Liz. That brings us nicely on to our second poll. Again, this is one looking at what you do in practice, and the poll should be there on your screen now, asking how do you tend to deal with Beckman liabilities arising in practice? And this is assuming that you are the transferee for these purposes. So 1, offer the employees a cash sum in settlement. 2, offer employees a lump sum into their existing pension. 3, agree with the old pension scheme to provide the enhanced benefit through that scheme. Or thankfully you've never had to deal with it in practice. So just give you a few minutes to click on there, and a reminder that there's still time to ask questions. If you want to submit questions at any point in the next few minutes, that'll be fine. And the questions are coming in. Thank you very much for participating in that. And I think we're looking like we have a clear winner. Okay, so the yellows have it by a long way, and the yellows are that you've thankfully never had to deal with it. So that's interesting in itself, Liz.
Yeah, absolutely. Well, I guess a lot of people are attending then just in case this ever happens in practice. So yes, it probably reflects, I think, our experience that Beckman rights come up occasionally, but you can imagine when they do, it's a financial potential nightmare for the transferee, so they want to get it right.
Absolutely. Okay, thank you. So we have a few minutes now for questions. So thank you for participating in that as well. Let's see. One of the typical questions that are coming in are on a very topical issue, which is relating to both of the speakers' subjects today, which is what impact Brexit might have on the issues we've raised today. So I'll ask Jane to answer that first.
Sure. Okay. Well, as with everything with Brexit, there's no change immediately. We haven't actually left yet. We've got the process to go through to do that. And what that actually means, obviously, is going to depend on the political will that prevails in how we come out. But in terms of